Welcome to Brad Explains the Law. Today I'm going to explain why there are so many Delaware corporations and why there are so many Delaware limited liability companies. But first I have to tell you that this video is not legal advice and I'm not your lawyer unless we sign an engagement agreement. There are many specific fact considerations and nuances on where you should form your corporation or whether your business should even be a corporation, and you should always consult with your own lawyer on your particular facts and circumstances before making any legal decision. So back to Delaware. Around 65% of Fortune 500 companies are domiciled in Delaware. Almost 90% of the companies that did an IPO in 2019 were Delaware entities. Delaware was one of the 13 original colonies. It's half the size of most of the counties in Colorado, and the entire population of Delaware is less than 1 million people, which is less than the Denver metro area and barely more than the city of Denver itself. So why is this lovely little sliver of land on the East Coast with great seafood the preferred jurisdiction of formation for so many corporations? Well, there are three primary reasons: history, continued maintenance, and efficiency. Let's look at history first. Delaware has a chancery court that specializes in business issues. The Chancery Court was formed in 1792. For context, that's only 16 years after the Declaration of Independence and 10 years after the end of the Revolutionary War. A Chancery Court is a court of equity. They come from feudal England. If you've watched shows like The Tudors and you see the monarch or bishop holding chapel court in the church, and people come in and tell him their complaints, and he orders resolutions based on fairness and common sense, that's a court of equity. Courts of equity filled in the gaps when there were not written laws, and there weren't very many written laws back then. Those courts made decisions based on fairness and common sense. That's what equity means. So for example, guy comes to the chapel and says, "My lordship, my neighbor's dog killed my lamb." And the king says, "Okay, neighbor, you owe him a lamb." The neighbor says, "I don't have any lambs." King says, "Okay, 2 chickens and a piglet." That is how equity courts administered fairness, although sometimes in a much more brutal way. So in the 1600s, the U.S. colonies, of course, followed English law. They were originally English colonies. And all of the colonies had chancery courts except for Delaware, which had only one court system for both legal matters and equity. Then, in 1792, when the other colonies, now the states, were getting rid of their chancery courts, Delaware established one because they needed a place to stash the top Whig judge when the Federalists took power in Delaware. But he was a good judge, and the judge the Federalists wanted to put in his place wouldn't agree to leave, wouldn't agree to go into that place unless they found something for the current judge. So as a compromise, they created a chancery court for him. His name was Justice Killen, the first judge of the Delaware Chancery Court. As a result, by 1800, Delaware had the only remaining chancery court of equity in the United States, and even England did away with them in the 1800s because of corruption. Also, until the early 1900s, there were no corporation laws. Corporations were only formed by an act of the legislature, so there were not very many corporations, and there were no particular laws about corporations. If you want to know more about the history of corporations, you can watch my video, What is a Corporation? So in the 17 and 1800, corporate disputes were in equity, not law, and in Delaware they went before the Chancery Court. In the mid-1800s, the Delaware Chancery Court, in resolving these disputes, started to develop the concepts of fiduciary duties for corporate directors. The duty of diligence, the duty of due care, the duty of disclosure, all developed from about 1840 to 1870. Then, in 1899, Delaware passed its General Corporation Law, which was one of the earlier corporation laws in the United States. As a result, the benefit of being a Delaware corporation grew even more because you no longer had to get an act of legislature to form a corporation in Delaware. By this time, the Chancery Court was specializing in corporation law, so it had the most case decisions, and now Delaware had a corporate law. So you could form a corporation in Delaware without a legislative charter, means more corporations are being formed, which means there's more case decisions. More case decisions means more certainty and predictability. So people form yet more corporations in Delaware. That is the historical genesis of Delaware's extensive corporate law. Another benefit is that every Chancery Court trial is to the judge, who is an expert in corporate matters, and not to a jury. There are no jury trials in Chancery Court, and this means faster and cheaper trials. Now, let's switch to continued maintenance. In the early 1900s, as corporations began to recognize Delaware as the preferred jurisdiction for formation, there was also an explosion in corporate litigation, which meant even more cases, and therefore more decisions and more law coming out of the Delaware Court of Chancery. The Delaware legislature recognized they had a potential industry by being the home jurisdiction and court system for corporations. Since that time, the Delaware legislature has been very active with its corporation law, amending it yearly, sometimes more often than yearly, to keep up with court decisions and to keep the law current. In fact, now Delaware earns more than $1 billion every year in entity filing fees and franchise taxes. So Delaware actively tries to keep this home court advantage business going. Now let's go to the third reason: efficiency. As a result of history and ongoing maintenance, Delaware law became the de facto corporate law of the United States. Most state courts look to Delaware law if there's not a relevant decision in that state, and they'll follow the Delaware decisions unless the relevant language of that state's law is different from the Delaware Act. And many state corporation laws either follow or are very similar to the Delaware General Corporation Law. And since corporation statutes don't cover everything, most corporate disputes are still claims in equity and common law. And Delaware has by far the most case law on those issues. Because of that, most corporate lawyers such as myself know at least two corporation laws: the law of the state they're in and Delaware. So, if we're forming a new fund or financing a company or doing a big merger or an IPO, we work with law firms all over the country. And regardless of where those lawyers are, they probably know Delaware corporation law. So if the parties are all Delaware entities, it's more efficient. The lawyers don't have to research and learn the laws of different states to do the deal. Also, venture capital funds, private equity funds, angel investors sometimes won't invest in non-Delaware entities. They know that their lawyers know Delaware law. They don't like uncertainty, and they don't want to learn or really pay their lawyers to learn Wyoming law, for example, just to make an investment. That's how Delaware corporate law developed. But what does that mean for clients? Well, there are some good reasons not to form in Delaware if you don't have to. First, if you don't live in Delaware, and almost no one does, and you end up in a lawsuit in Delaware Chancery Court, you have the expense of hiring Delaware lawyers and paying your lawyers to go to Delaware for hearings and trials. Very expensive and time-consuming. For more mundane, administrative, and practical reasons, let's compare Delaware to Colorado, although it's not really a fair comparison, because Colorado is by far the easiest, cheapest, most efficient, and business-friendly Secretary of State office in the country, and it has been for decades. On the other hand, Delaware's not the worst, but it's not Colorado. For example, I can file your articles and form your Colorado corporation online in about 2 minutes for a $50 filing fee. I can form your Delaware corporation in 30 minutes if it's an emergency for $1,500. Otherwise, it takes several days and costs, I think $150. I can renew your Colorado corporation and pay the annual $10 fee in about 1 minute. In Delaware, the annual corporation franchise tax ranges from $175 to to $250,000 depending on the size of the corporation. So if Amazon was a Colorado corporation, I could renew and pay their $10 annual fee in about a minute. In Delaware, Amazon's annual franchise fee is $250,000. Now, you might be wondering, should your company be a Delaware corporation? Well, if you're planning on rapid growth, several rounds of outside investors, maybe an eventual IPO or trade sale exit, yes, probably should be Delaware. Your investors will probably want that. It's more efficient in the long run. But if you're forming a company to conduct a local or regional business, you don't anticipate rapid growth and multiple investment rounds, you should probably form in the state where you're located. Now let's switch to LLCs. Why are there so many Delaware limited liability companies and limited partnerships for that matter? Well, Delaware was the fourth state to adopt a Limited Liability Company Act in the mid-1990s after Wyoming, Florida, and Colorado. But Delaware's LLC Act was unique because it was very flexible. I explain all of this in detail in my video, What is a Limited Liability Company? Since that time, Delaware has remained active and aggressive updating its LLC Act. And disputes about Delaware LLCs also go to the Delaware Court of Chancery. Limited partnerships and LLCs are often used for investment companies like hedge funds, private equity funds, so for the same reason as corporations, they like to form in Delaware. As a result, Delaware has a lot of case law about LLCs, although not a striking amount more than other states because LLCs are so new. However, Delaware is one of very few states to adopt series LLCs, which are particularly useful for structured finance funds and securitizations, which are very complex and beyond the scope of this video. I'll do another video about those in the future. So Delaware stays on the cutting edge of LLC law, just as it does for corporations. There you have it, the reasons why so many entities are registered in Delaware. And that will probably continue for the foreseeable future. Thanks for watching. Hit like and subscribe below if you enjoyed this topic. And if you have any questions or want me to discuss another topic, send me an email at the address below.